afternoon, everyone. I see that we still have a few more people to come in. So thank you to those who have joined us early. We'll be starting shortly at 3 p.m. For those of you who have joined early, we really appreciate your patience. While we wait, allow us to share a quick video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Proposed Citizenship Amendments Impact on Stateless Children. I'm Anis, and I'll be your moderator for today's session. Before we dive into today's talk, I'd like to take a moment to introduce you to the firm and share a little bit about what we do. Mao & Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mao & Kwai. Our able team today comprises 32 lawyers and a support staff of 26. Datuk Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. Our firm proudly partners with SMEs, family-run businesses, and individual clients. We are a full-service law firm offering a wide range of expertise. This includes our corporate department, dispute resolution team who handles litigation, adjudication, and arbitration. We also have a dedicated employment team and a department focused on servicing the unique needs of individuals and families. Our practice groups reflect some of our focus areas, bringing together talent from both our corporate and dispute resolution departments to deliver solutions to our clients. Today's session is part of Mao & Kwai's online talk series. For a bit of background, we've been hosting monthly lunch talks at our office since 2013, and we moved the series online since COVID-19 hit to continue our mission of sharing knowledge, raising awareness, and fostering connections among clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. I have the pleasure of introducing our speakers today. So we have two. So allow me to introduce the first speaker, Kirthika. Our first speaker is, I will say, a visionary. Perhaps that's why she's speaking to you today on the proposed amendments to help you get ahead of these legal amendments. She was admitted to the English bar in 2021 and the High Court of Malaya in 2023. So she is an associate under our dispute resolution department who regularly advises on citizenship issues, employment disputes, among other areas. Our second speaker is Aishah. She was admitted to the Malaysian bar in 2024 and also regularly advises on citizenship issues as well as construction litigation. On screen now are the key topics that our speakers will be covering today. We will have a Q&A session at the end, so don't forget to type your questions in the Q&A chat box at the bottom of your screen. On that note, I'd like to invite our first speaker, Kirthika. The stage is yours.
Thank you again, Anis, for that very sweet introduction. As introduced by Anis, I will be going through the first two top topics for today, and following which Aishah will go through the proposed amendments, specifically the proposed regressive amendments and the impact that it will have on stateless and vulnerable individuals. So just to give you a bit of background, I will be going into the first two talk topics, which cover recognition of citizenship by operation of law under Article 14, subsection 1, subsection B, followed by the recognition of citizenship by registration under Article 15 of the Federal Constitution. Now, the reason why we focused specifically on Article 14, subsection 1, subsection B, is because it governs individuals that were born after Malaysia Day, as opposed to Article 14, subsection 1, subsection A, which governs individuals born before Malaysia Day. So in an effort to stay relevant to today's topic, we will be specifically focusing on Article 14, subsection 1, subsection B. To break down Article 14, subsection 1, subsection B, you will see on our slides essentially a table summarizing the different methods for recognition of operation of law. Article 14, subsection 1, subsection B is read together with the provisions under Part 2 of the second schedule of the Constitution. So this is broadly subdivided into two categories: those who are born within the Federation and those born outside the Federation. So the Federation here is in reference to obviously Malaysia, and so that under this there are two different individuals who are born within Malaysia and outside of Malaysia. So very important to note, there are 5 provisions here, as you can see on the slides. There's subsection 1A, 1B, 1C, 1D, and 1E. So under section 1A, it governs those who are born within the Federation. Essentially, under section 1A, an individual is entitled to Malaysian citizenship in the event either one of their parents is a Malaysian or a permanent resident, importantly, at the time of the person's birth. So in the event either of their parents becomes a Malaysian citizen after their birth, then they would not fall under the category of section 1. The next category of those individuals born within the Federation is section 1E. The requirements under section 1E is obviously the first, that you must be born within the Federation. And secondly, that you must not be born a citizen of any country. Now, this meaning of not being born a citizen of any other country is expounded further by section 2, subsection 3, which provides that a person is to be treated as having acquired citizenship at birth if he has acquired citizenship within 1 year after his birth. So, for example, if you were born in 2004, if you acquire citizenship of any other country within 1 year, so within 1 year after 2004, you would then not be eligible under section 1E to qualify for Malaysian citizenship. Now, the remaining category of individuals are those born outside Malaysia. Now, I'm very sure a lot of you would have heard about the issue of individuals being born outside of Malaysia to Malaysian mothers, and that's, I feel, has become very predominant in the news, and I will actually go into that further. But for now, section 1B covers those individuals whose father is at the time of birth a citizen and was born in the Federation, and as well as if the individual's birth is registered within 1 year at a consulate of that country. For example, if an individual is born in the UK, for example, if their father is a Malaysian citizen, and if as long as the child's birth is registered in the consulate of that country, so the UK, within 1 year of the child's birth, then the child will then be entitled to citizenship pursuant to section 1, subsection B. Section 1, subsection C, on the other hand, has very similar conditions. However, there is no requirement for registration. Instead, it requires that the individual's father be born a citizen in Malaysia. So essentially, the individual's father has to be a Malaysian citizen born in Malaysia, whereas that qualifier is not present under section 1, subsection B. Alternatively, the individual under section 1, subsection C, the father would need to be in service of the Federation. Now, there's no actual definition of service in service of the Federation, but presumably covers individuals whose parents are, for example, in the army, in the navy, essentially in public service at the time the child was born. Section 1, subsection D covers those individuals who are born in Singapore and whose parents, one of at least at the time of that child's birth, is a citizen, and at that time of the child's birth is not born a citizen. So born a citizen is again applied the same connotation under Section 2, subsection 3. So now that I've briefly spoken about each of the provisions under Part 2 of the second schedule, our focus for today's talk will be specifically on sections 1A, B, C, and E. We won't be covering subsection 1, subsection D, as technically those individuals would also be subsumed under section 1, subsection E, and section 1, subsection A, depending on certain circumstances that they fulfill. So section 1, subsection A of the second schedule, born to a Malaysian parent. This, as discussed previously, section 1 is read together with Article 14, subsection 1, subsection B. Essentially, those individuals born on or after Malaysia Day and having the qualifications specified in Part 2 of the second schedule. So that the person must be born within the Federation and at least one of the parents is a Malaysian citizen or a permanent resident at the time of the person's birth. So 3 very important qualifiers: born on or after Malaysia Day in Malaysia, at least one of the parents is a Malaysian citizen or a permanent resident, and this has to be at the time of the person's birth. Sections 1B and C, born overseas to a Malaysian father. So as discussed, these are the qualifiers for individuals who are born outside of Malaysia. And as long as they fulfill the conditions under section sub 1, subsection B, that is, you're born outside of the Federation and is either born in the Federation or is at the time of birth in the service of the Federation or of the state. So then they would qualify under section 1, subsection B. And similarly for section 1, subsection C, father is at the time of birth a citizen and the person's birth is registered at the consulate within 1 year of the person's birth, or specifically for Brunei, registered with the federal government. So this registration with the federal government is specific only for those individuals who are born in Brunei. When it comes to sections 1A and 1B and 1C, we see this word parents, or at least for 1B and 1C, specifically the word father. What does the word parents mean exactly in 1A? And does the word father include mother when we talk about essentially a child whose Malaysian father is born? When a child is born overseas and the father is Malaysian, does that also include a Malaysian mother, or is it only limited to Malaysian father? So what I'll do now is I'll go into a few recent cases, and we'll essentially analyze these 2 issues, what exactly the word parents means, and whether father includes mother as well when it comes to section 1B and 1C. So we have the case of CTEB and another. In the case of CTEB and another, the child was born overseas and the child was born out of wedlock, meaning the child was born before his parents were married and the child was born in Philippines. Now, from the case of CTEB, we see that parents refers to purely parents in a recognized marriage. That is, it has to be a marriage recognized within Malaysia, and therefore, pursuant to this case, it wouldn't include individuals who were born outside of wedlock. However, this position has since somewhat been set aside, and we'll actually go into the logicking of the judges in this case in the next few slides. So the basis of the reasoning for essentially finding the child was not entitled to citizenship can be found in the majority judgment of the case of CTEB. Essentially, that there's an express distinction for parents or father of an illegitimate child under Section 17, and that the word parents in the context of Part 3 of the Federal Constitution must be construed to refer to lawful parents in a recognized marriage in the Federation. So this would always mean legally wedded parents, as opposed to the biological father and mother. What exactly does this reference to Section 17 mean? Section 17 of Part 3 of the second schedule of the Federal Constitution provides that for the purposes of citizenship, any references to an illegitimate person's father or parent will be construed as references to his mother. So essentially, whenever there is reference to the word parent, in under sections 1A through to 1E, this would be a mother in the event the parents of the child are not married at the time of the child's birth. So essentially an illegitimate child. However, it's interesting to note that in CTEB, it wasn't a unanimous decision, meaning not all judges in the panel of judges at the federal court agreed when it came to the decision. So it was a split decision. I believe there were 4 judges in the majority and 3 judges in the minority. The majority judgment found that the child in CTEB was not entitled to Malaysian citizenship, whereas the minority actually were of the view that the child was entitled to Malaysian citizenship for the reasons as follows. So the minority judgment, each of the minority judges wrote their separate and distinct judgments. Part of the extract which on the slide is from the Learned Chief Justice of Malaysia, Yang Arif Tengku Maimun. And you can see her ladyship's logicking here that the word father in 1B of part 2 and anywhere else ought to be construed to mean biological father. Therefore, the legitimacy status of any person claiming for citizenship under Article 14 sub 1 sub B is an irrelevant factor when the paternity is known. So in this case, her ladyship found that Section 17 will only be applicable in situations whereby the biological father is not known. So essentially, only in situations where the biological father is not known, and if the word parent would be construed to mean father only, the child would essentially end up being stateless, as the mother would not be able to pass down her citizenship to her child. So the learned judge essentially found that interpreted Section 17 to be a provision to protect individuals from being stateless, as opposed to a qualifier to prevent individuals from getting citizenship. As you can see here, there is a difference in interpretation when it comes to Section 17. And her ladyship further went on to say that it's essentially irrelevant whether or not child's parents were married, as long as the identity of the biological father is known. Another federal court judge, Yang Arif Nalini, also gave her grounds and basically concurred to a large extent with Yang Arif Tengku Maimun's judgment, as well as can be seen here. It should only arise where there is no Malaysian father, or it does not follow that the citizenship of legitimate biological father of a child can be ignored in its entirety simply because the mother and father are not married. And you see a similar thought process here as well in Yang Arif Mary Lim's, as her ladyship then was, judgment as well. So it does not alter the status of the entitlement to citizenship. So what's interesting here in CTV is that you have a split view from the Learned Federal Court panel who decided on this case. Now, this is very important because following the case of CTEB, we have the case of CH, where the facts between CTEB and CH are slightly different. In CH, the child was born in UK, in Malaysia. The child's biological parents were unknown, and the child was handed over to a Malaysian couple for adoption. Because the child's original birth certificate stated the Malaysian parents as their biological children, child's parents were then called in for investigation, and the original birth certificate was surrendered to JPN and cancelled. So essentially what had happened was, because of the cancellation, the child was then rendered stateless, and the applicant here filed an application for judicial review in the High Court of Kuala Lumpur. And this case essentially went all the way up to the federal court. And just to take a step back, the child here was eventually granted citizenship pursuant to Section 19 of the Federal Constitution, specifically Section 19B, Part 3 of the second schedule of the Federal Constitution. Now, if you'll notice, Section 19B wasn't mentioned in my slides earlier, specifically because I wanted to address Section 19B in the context of CCH. Section 19B provides that for the purposes of Part 1 or Part 2 of the schedule, any newborn child found exposed in any place shall be presumed until the contrary is shown to have been born there, for mother permanently resident there, and the date of finding shall be taken to be the date of birth. Essentially what this means is, in the event there's any child abandoned in Malaysia, the child shall be presumed to have been born to a mother who's permanently resident there, thereby fulfilling the qualifications under Section 1A, Part 2, because the child would then be presumed to be born to a parent permanently resident in Malaysia, and the child would have been born in Malaysia. So then the child will have been presumed to have successfully, rather be qualified for citizenship pursuant to Section 1A. But even though the factual circumstances between CTEB and CCH were quite different, the judges in CCH adopted the minority judgment of the judges in CTEB as follows, essentially. Basically, they, in analyzing the principles when it came to CTEB, they essentially referred to CTEB and stated that Part 3 contains enabling provisions, which is meant to assist or aid in the interpretation of Parts 1 and 2, and does not qualify or conditionalize the applications of Part 1 and Part 2. So essentially, this is in reference to provisions such as Section 17, as discussed earlier. And why this is relevant is because essentially the federal court judges in CCH said that the provisions under Part 3 are not meant to prevent citizenship. So essentially, Section 17 is not meant to prevent individuals from being entitled to citizenship. Rather, it is meant to protect individuals and ensure that Malaysian mothers are able to pass down their citizenship to their children in the event that the child's biological father's identity is not known. So then the federal court judges in CCH go on to say, we adopt the reasoning there as a part of this judgment being the only other decision of the federal court, apart from this one, to have touched on this issue most recently. So in a sense, they adopted the minority judgment in CTEB in saying that, in finding that the provisions under Part 3 are actually enabling provisions as opposed to provisions that qualify or conditionalize the applications of Part 1 and Part 2 to Part 3. So when it comes to whether the word parents includes legitimate parents, individuals who are, whether it covers individuals who are illegitimate or not, it still hasn't exactly been addressed, or rather this matter is arguably not fully settled as yet, as the effect of the CCH's judges adopting the minority judgment in CTEB hasn't exactly been confirmed by the federal court as yet. And therefore, we are actually looking forward to the upcoming federal court cases to see if any of the federal court judges actually do clarify this matter. And if they do, it would obviously be beneficial as well, once and for all, provide finality as to whether the word parents does include individuals who have been married, or whether it includes individuals who have not been married, or whether it includes individuals who have been, or only refers to individuals who are married, or rather, to put it simply, whether it covers individuals who are illegitimate, or whether it only refers to individuals who are legitimate. Moving on to whether the word father in reference to Section 1B and Section 1C of the second schedule. This is a very interesting case study because Malaysia Sulaiha and other cases is essentially two sets of appeals, which as of now, or rather the judgment that we're referring to is the Court of Appeal judgment. So there are two sets of cases. One is the case that I'm sure a lot of you will be very familiar with and is often referred to as the Family Frontiers case, which started as an originating summons at the High Court. And the second appellant is Malaysia Sulaiha, whose originating summons was also started at the High Court. But unlike the Family Frontiers case, Malaysia's originating summons was disallowed at the High Court. Now, in both cases, they were taken from the High Court and appealed to the Court of Appeal. In Malaysia's case, it was the appellant herself who filed an appeal. And in the Family Frontiers case, it was the defendants, that is the government of Malaysia, the National Registration Department, and other parties who filed an appeal against the High Court's decision of granting the individuals therein citizenship. Now, the individuals concerned were all born overseas to Malaysian mothers and foreign fathers. And essentially, the core issue which was determined on appeal is whether the word father in sections 1B and C ought to be interpreted to mean father and mother. I'm not going to go over the reasoning of the Court of Appeal in disallowing the Malaysia's appeal and allowing the Family Frontiers appeal, basically finding that the individuals were not entitled to citizenship, as the word father does not include mother. Also, similar to the case of CTEB, this was a 3-bench panel unlike CTEB actually, which was a 7-bench panel. In this case, there were 3 judges. Out of the 3 judges, 2 judges were in the majority in finding that the individuals were not entitled to citizenship. And there was a lone judge who disagreed with his learned brethren and found that actually the individuals here were entitled to citizenship. So I'll just briefly go through the grounds of judgment from both perspectives so that we can actually see the reasoning of the learned judges. Yang Arif Kamaluddin here found that essentially the word father, the use of the word father here is essentially deliberate, and it's contrasted with the other qualifications under the other provisions, that is section 1A and 1D. It's contrasted because the word father here is contrasted with the other qualification, which is whose parents, one at least. So essentially, he found that the provision itself is clear, and had the drafters of the federal constitution intended for mother to be included, they would have simply used the word father, and any other interpretation other than the direct one would basically change the feature of the federal constitution, which would not have been intended by the framers of the federal constitution. Yang Arif Aziza Nawawi also came to a similar conclusion, essentially that the High Court cannot adopt the position to rewrite the federal constitution by declaring the word father to also include mother, and essentially that the federal constitution had gone through so many amendments since its original draft form that if the federal constitution had intended to include mother, they would have done so at any point since, and they haven't done that. In contrast, Yang Arif Nandabalan found that there is a provision under the federal constitution, namely Article 8 sub 2, which expressly provides gender discrimination, basically that men and women are to be treated equally. And the thrust of both appellants, one appellant and one respondent here, is that Article 8 sub 2 expressly provides discrimination, and if sections 1B and 1C were only to apply to Malaysian fathers as opposed to Malaysian mothers, the provisions would then therefore become discriminatory in nature. So Yang Arif Nandabalan actually agreed and adopted part of that reasoning in his judgment, and he said that had the government intended to limit the application of Article 8 sub 2, they would have done so, basically saying that if Article 8 sub 2 was not to apply to the citizenship provisions under Article 14.1 subsection B, then the Parliament of Malaysia would have simply included an exclusionary provision saying that Article 8 sub 2 doesn't apply to Article 14 sub 1 sub B, right together with Section 1 sub B. So basically, he found that because there was no such qualification or no such exclusionary clause, Article 8 sub 2 did apply to Article 14B, and because it did apply, Section 1 sub B should be interpreted to include the word mother and not just father. So he essentially dissented with his learned brethren, and it's quite interesting actually, because in both CTEB and in Malaysia Sulaiha's case, it's interesting because the individuals there were not granted citizenship ultimately. And even in granting such a decision, both panels were quite split, almost down the middle when it came to granting their decision. It should be noted that both Malaysia Sulaiha and the family group of plaintiffs have filed their respective appeal applications for leave to the federal court, which have been granted, and the appeals at the federal court are now pending and scheduled to be heard in December this year. Essentially, the Court of Appeal judgment may or may not be applicable depending on how the federal court decides later this year. Now, we move on to Section 1, subsection E, individuals born in Malaysia. So I'm not going to go over these provisions again, but basically it covers every person born within the Federation who is not born a citizen of any other country. And a person is to be treated at having birth, any citizenship which he acquires within 1 year after his or her birth, essentially. If an individual has not acquired citizenship of any other country within 1 year after their birth, and the individual is born in Malaysia, the individual will then be entitled to Malaysian citizenship. Now, we have, similar to the other provisions, we have a case study But before going into the case study essentially examines whether the identity and citizenship of an individual's biological parents are relevant in the determination of citizenship. Essentially, unlike the other provisions, Section 1E doesn't have any reference to the word father, parents, mother, none of those provisions. So the question that we would like to analyze rather is whether the identity of a person's biological parents are relevant in the determination of citizenship. So, for example, in the event an individual who is born in Malaysia has not obtained citizenship of any other country within 1 year of that person's birth, is that person's biological parents' nationality then relevant? So, for example, if the person has one Malaysian father and an Indonesian mother, is that relevant to the determination of citizenship under Section 1E? So the first case that we're going to look at is the case of Wong Queng Hui. Now, in Wong Queng Hui, the individual was born in Malaysia, specifically in Sabah, and individual was born essentially to a Malaysian mother and a foreign mother. Now, the individual's parents were not married at the time of the individual's birth, which is why JPN, or the National Registration Department, took the position that the individual was not entitled to citizenship. So as you can see here, the High Court declared that the applicant was a citizen of Malaysia by operation of law by virtue of his birth in Malaysia pursuant to Section 1E, as the details on the applicant's birth certificate, which was issued by Malaysian government, were conclusive in nature. Essentially, that the child's birth in Malaysia within the Federation was taken as conclusive evidence as the birth certificate was issued by Malaysia. In this case, essentially, the High Court answered only the birthplace, or rather the birthplace, you look at the birthplace of the individual, as long as that condition is fulfilled, and the child would then be entitled to Malaysian citizenship. Now, we haven't included extracts of the judgment in the slides, as the judgment from the High Court was drafted in Bahasa Malaysia, and I'm not sure whether all of our participants are fluent or conversant in Bahasa Malaysia, but in the event you do actually want a copy of the judgment, or in the event you actually would like to read this, you can contact our team and details will be provided after this talk. Now, in Wong Queng Hui, the respondents filed an appeal to the Court of Appeal. The respondents here, as you can see, were the National Registration Department and other parties, essentially governmental bodies. Now, the Court of Appeal affirmed the High Court's decision in that the respondent, that is Wong Queng Hui, was a Malaysian citizen by operation of law by virtue of his birth in Malaysia, pursuant to Section 1, subsection E of the second schedule. Now, the government of Malaysia tried to apply for leave to appeal this decision of the Court of Appeal. However, the application for leave was rejected. Therefore, the Court of Appeal judgment stands. Now, what's interesting is that I'm going to take you to another case, also delivered by the Court of Appeal, but the Court of Appeal essentially came to a completely different reasoning in finding that the individual was not entitled to citizenship. This is in reference to the 2022 Court of Appeal case of TSY. In TSY's case, the appellant was born in Malaysia. She was initially registered as a Malaysian citizen as her adoptive parents. I use the word adoptive here because they didn't legally adopt TSY. They just registered themselves to be her parent. The application was then made to correct the particulars on the appellant's birth certificate, that is removing the names of her quote-unquote adoptive parents, which then rendered her stateless. Now, the appellant's originating summons in the High Court was dismissed, and on appeal, the Court of Appeal upheld the decision of the High Court. That is, they dismissed the appellant's appeal. This is the reasoning of the Court of Appeal in short. I've just taken a short extract from the judgment. Essentially, that the requirement of jus soli, and in the absence of the identity of the appellant's biological parents, jus sanguinis is not satisfied, and one cannot determine whether she is stateless for the purpose of paragraph 1E, part 2, second schedule of the Federal Constitution. Essentially, the Court of Appeal judges adopted the view that under Section 1, subsection E, there is two requirements, jus soli and jus sanguinis. Jus soli is the birth requirement, i.e. that the child or the individual must have been born in Malaysia. In this case, the appellant very clearly fulfilled the jus soli requirement. However, in addition to the jus soli requirement, the Court of Appeal found that there is an additional requirement of jus sanguinis, that is to prove the identity of the appellant's biological parents. So therefore, the Court of Appeal held that the identity and nationality of the appellant's parents in determination of citizenship pursuant to Section 1E is relevant in determination of a citizenship, in determining whether an individual is entitled to citizenship pursuant to 1 subsection E. So we have two very clearly contradicting Court of Appeal judgments, and one can argue that on the facts of the case, they're quite dissimilar, and essentially that's what the Court of Appeal held in TSY's case. They held that they weren't bound by the decision of Wong Kuen Wei on, amongst others, the fact that the factual background in both cases were very different. It should be noted that much like Malaysia and the Family Frontiers Group, the appellant in Tan Soo Yin did apply for leave to appeal the Court of Appeal's decision, and leave was granted, they should say 26th of July 2023, and the federal court hearing is also similarly scheduled in December of this year. So the cases of Mahisha Sulaiha, the Family Frontiers case, and TSY's case are all scheduled to be heard together in December later this year, at least presently fixed to be heard later this year. It should be noted that the Court of Appeal decision may very well not stand, depending on the decision of the federal court. Now that I've gone through my very lengthy introduction of Article 14(1)(b), I'll now go into application for citizenship by registration under Article 15A of the Federal Constitution. Now, under Article 15, I know that I said that we would focus on specifically Article 15A, but there's also another provision under Article 15(2). Article 15(2) and Article 15A essentially provide that individuals under the age of 21, for Article 15(2), whose parents of one at least is a citizen, can apply to be registered as Malaysian citizen. Similarly, under Article 15A, the federal government may, in special circumstances, cause any person under the age of 21 to be registered as a citizen. Two very important things to note here. One, there is an age qualifier. And two, as opposed to citizenship by operation of law, the individual here is not automatically entitled to citizenship. It is by way of registration. I've essentially created a very quick table summarizing the differences between citizenship pursuant to Article 14 and that pursuant to Article 15A. So as I said, citizenship under Article 14, you are automatically deemed a citizen, whereas under Article 15, it's not automatic. You have to apply by way of the NRD or KDN, which is the Ministry of Home Affairs. So you would submit your application to the NRD, and it's then considered by NRD and subsequently by the Ministry of Home Affairs. Pursuant to Article 14, you would be deemed a citizen from your date of birth, whereas under Article 15, your citizenship is from the date of granting of citizenship. So once you've applied, in the event your citizenship under Article 15A is granted, you would then be deemed a citizen from that date as opposed to from birth. Under Article 14, your birth certificate states that you are a citizen. So if you would see a birth certificate issued in Malaysia, it will either say warga negara or bukan. Pursuant to Article 14, you will be a warga negara, whereas under Article 15A, you will still be bukan warga negara, but you will be issued a separate certificate of citizenship. Under Article 14, there is no age limit, so you can be deemed a citizen of Malaysia at any age. There is no age limit. There is no cutoff in any manner whatsoever. However, pursuant to Article 15A/15(2), only those who are under the age of 21 are eligible to apply. So there is a cutoff limit here. How do you apply for citizenship pursuant to Article 15A? Like I said, the application is submitted by way of a form to JPN or the National Registration Department. The parents of the applicant or the guardians of the applicant, the parents here must be present, and it can either be the parents or the guardian. But the guardian, one thing to note with the guardian is that the guardian must have familial ties with the applicant. So they can proceed to submit the application for the applicant, but the applicant must be present when the application is submitted. And these requirements are per JPN's website, and you can actually find it if you just Google Permohonan Kewarganegara under Perkara 15A. So you can find this on their website. So the application is done by way of filling a form. Then you would need to attach supporting documents. So JPN has a checklist of documents that you need. And once you've filled in the form, attached the supporting documents, you would then need to pay an application fee of 10 ringgit. Once you've paid the fee, it can take anywhere between 2 to 4 years, or even up to 6 years we've seen in the past, for the application to be processed. If granted, a fee of 100 ringgit is payable for the issuance of the certificate of citizenship. One thing to note, which I haven't stated on the slide, is that if you apply and your application is rejected, there's nothing stopping you from applying again. So you can apply again, provided that you're under the age of 21 when you apply. So it doesn't matter if you apply, then you turn 21. That's irrelevant. So long as you are under the age of 21 when you apply. I'll now hand over to Aishah to discuss the proposed amendments to the citizenship provisions in the Federal Constitution. Aishah, over to you.
Thank you, Kirthika, for guiding us through the current citizenship law under the Federal Constitution. Moving on, today's talk will focus on the regressive amendments, which will impact stateless and vulnerable individuals. Now, looking into the proposed amendments to the citizenship provisions in the Federal Constitution, the suggestion for amendment of the Federal Constitution came about early 2023 as a result of issues faced by Malaysian mothers married to foreigners who then gave birth to children overseas and were not able to confer citizenship on their children, as in the case of Mahisha Sulaiha and others as discussed by Kirthika earlier. In June 2023, this proposed amendment was included as a part of comprehensive amendments to the Federal Constitution in an attempt to restrict citizenship rights for several groups of stateless communities. I will now go on to discuss the initial proposed regressive amendments, the first one being amending Section 19B of the Second Schedule, Part 3 of the Federal Constitution, to alter citizenship by operation of law to citizenship by registration, which will then result in foundlings and abandoned children being deprived of automatic citizenship. Secondly, amending Section 1A of the Second Schedule, Part 2 of the Federal Constitution to delete the words permanently resident, which will then result in children born to Malaysian permanent residents, PR, who would eventually become stateless, to no longer have access to citizenship by way of operation of law. Thirdly, amending Section 1E, Part 2 of Second Schedule to alter citizenship by operation of law to citizenship by way of registration. Fourth, the amendment is to amend Article 26, Subsection 2 of the Federal Constitution by allowing the Home Ministry to deprive a foreign wife of citizenship in the event their marriage is dissolved within 2 years from the date of obtaining citizenship, as opposed to within 2 years from the date of marriage. And amending Article 15A of the Federal Constitution to reduce the age limit from 21 years to 18 years for citizenship registration, effectively shortening the time frame for the applications. However, following the feedbacks that we received from various non-governmental organizations, NGOs, the Home Ministry then decided to drop 2 out of the 5 regressive amendments in March 2024. So the 2 amendments that were dropped, the first one is the proposed amendments to Section 19B of the Second Schedule, Part 3 of the Federal Constitution to alter citizenship by operation of law to citizenship by way of registration. And secondly, the proposed amendments to Section 1E, Part 2 of the Second Schedule to alter citizenship by operation of law to citizenship by registration. Now we're moving on, we're now going to have to take a look at the Constitution Amendment Bill 2024, where the first reading was carried out on 25th March this year. And as of now, the bill is currently scheduled to be passed during the next parliamentary session in October to December this year. And the Constitution Amendment Bill 2024 in its current form contains a saving provision which provides that the amendments will not apply retrospectively, which we'll be discussing this onwards. Now, moving on, I will talk about why the proposed amendments are regressive and the adverse impacts of the proposed amendments, specifically on stateless children. So the proposed amendments to Section 1B and 1C are adverse in nature because it only applies prospectively, which means the benefit of the amendment to Sections 1B and 1C will not impact individuals born before the coming into operation of the Act, as you can see from the slide. Where the status of citizenship of any person born within or outside the Federation before the date of coming into operation of this Act shall, on the date of coming into operation of this Act, be dealt with in accordance with Part 3 of the Federal Constitution, as if the Federal Constitution had not been amended by this Act. And moving on, you can see that it says also that any application made by any person to the federal government under Part 3 of the Federal Constitution, which is pending before the date of coming into operation of this Act, shall, on the date of coming into operation of this Act, be dealt with in accordance with Part 3 of the Federal Constitution, as if the Federal Constitution had not been amended by the Act. So whilst the amendment to Section 1B and C is long awaited, the amendment comes with a caveat, which means it applies prospectively. So the amendment is adverse in nature because children born overseas to Malaysian mothers married to foreigners will not benefit from the proposed amendment. It should be noted that the amendment is in the bill stage and this provision may be amended further by the Parliament. Now, moving on to the proposed amendment to Section 1A. So under the current provisions, Malaysian-born children with at least one Malaysian permanent resident parent are citizens by operations of the law. The Home Ministry now intends to delete the words permanently resident to take away the PR's children's automatic right to citizenship. This means that their only pathway to citizenship is through ministerial discretion. Now, looking into Section 26, amendment to Section 26, Section 2, currently one of the criteria for citizenship stripping of foreign wives is if their marriage is dissolved within 2 years of their date of marriage. So this was put in place to prevent what has been called as marriage of conveniences, where it also refers to transactional marriages for the purpose of citizenship acquisition. Now, the Home Ministry is currently proposing to grant themselves the power to deprive a foreign wife of citizenship should her marriage be dissolved within 2 years of their date of obtaining citizenship. Therefore, if a foreign wife marriage is dissolved after 2 years of obtaining the Malaysian citizenship, which is later than one's date of marriage, the government can now deprive her of her citizenship, which would eventually render her stateless, since Malaysians over the age of 21 cannot hold dual citizenship. So it makes the foreign spouse extremely vulnerable to potential violence and abuse without the ability to extricate herself from the situation without now risking her citizenship. The increased time requirement now creates a new power dynamic between the Malaysian husband and his foreign wife. With citizenship on the line, the foreign wife would now face prolonged external pressure to keep her marriage intact, even in situation of abuse, coercive control, or intimate partner violence. Currently, most stateless children can only apply for citizenship through Article 15A. It should be noted that only those below the age of 21 years old can go through this route. The proposal now meant to change the age bracket from 21 years old to 18 years. What this means is that once they turn 18, stateless individuals will have very little to no recourse to apply for Malaysian citizenship, especially because other registration-based citizenship pathways have historically been out of reach for stateless communities because of its strict criteria. And this is also further exacerbated by the fact that it takes an average of 3 to 6 years for 15A applicants to receive a Home Ministry applicant decision, who are unlikely to be successful on their first try. And even after all that, they will still need to repeat the whole cycle again because the chances of which would be severely reduced if the age limit for application is reduced from 21 to 18 years of age. So what now is that in light of the proposed amendments, we recommend that individuals eligible to apply for citizenship pursuant to Article 15A to do so as soon as possible. So if you have any further inquiries regarding the application process, you may contact our team for a consultation, details of which will be then provided at the end of this talk. So that will essentially conclude my part of the talk today, and we can move on to the Q&A section.
Okay, thanks, Aishah. Thank you as well, Kirthika. That was a lot to take in, but really good points there. We will now take questions from the participants posted in the Q&A chat box. I believe there is one from Yasir. I'll direct this to you, Kirthika. Essentially, they would like to know whether in this scenario, whether the child can become Malaysian. So for a Malaysian woman citizen, for a female Malaysian citizen that is married to a foreigner abroad and has a certificate of marriage from another country, which certificate will be converted to a Malaysian one, and considering that the child is born in Malaysia, would this child be then considered Malaysian or become Malaysian, Kirthika?
So this would actually depend on a few factors. The first one being whether the certificate of marriage which is referred to was actually applied for before or after the children were born. Another thing to consider is that in the event the individuals involved were Muslim, there are further requirements pursuant to Sharia law because in order to determine whether the marriage certificate was in compliance with the Sharia law in Malaysia, there are certain requirements that need to be met. If you have further questions on the requirements, I would actually recommend contacting us after this talk. We can perhaps actually look into it because this question is actually very situation specific, because I'm guessing from the individual's name that the individual is Muslim. So it's quite situation specific, and we would actually need to take a look at the documents first before we can advise further.
Thanks, Kirthika. I think we also have another situation, a very specific situation that Min Sang Chan also wants a clarification on. I think, Aishah, you can take this one. In the case where there's a Malaysian father, the child is born outside of Malaysia, but is not registered. Is there any chance of this child getting a Malaysian citizenship?
Okay, thank you for the question. And to answer this question is that, firstly, yes, depending on whether the father is a Malaysian born in Malaysia. So if the father is a Malaysian born in Malaysia, then yes, you would be pursuant to Article 14, 1B, read together with Section 1B, Part 2 of the Second Schedule of the Federal Constitution. However, if the answer is no, that the father is not a Malaysian born in Malaysia, then what we recommend is that perhaps you can schedule a consultation, particulars of which will then be provided at the end of this talk, because again, this could also mean a specific situation, and maybe we require a further consultation on this matter.
Okay, thanks, Aishah. I see that we are running out of time, so I think I'll go with one more response. So this attendee is anonymous, but they had a few questions. First, okay, whether the slides will be available. Yes, they will be after the talk. Secondly, did the court in TSY's case explain how one can positively prove their statelessness with regards to Section 1E? And if the biological parents are unknown? And thirdly, what are the reasons that the first-time applications under Article 15A are rarely approved? Maybe you guys can take one each, or which one would...
I think I can actually just take both because they're related. In TSY's case, they didn't actually go into how one can positively prove their statelessness if the biological parents are unknown. And this is actually one of the points, or rather one of the questions on basis on which the applicant in Tan Sri Yun actually filed for leave, because you can't be expected to prove a negative fact. And if the applicant doesn't know who her parents are, how is she expected to prove their identity, right? The other thing to consider is that in normal situations where the child's biological parents are not known, they will usually qualify for citizenship ordinarily under Section 19B, read together with Section 1A. The reason being, normally, if the biological parents are not known, it's usually because the child was either abandoned or left basically abandoned. And in that case, it would then be much easier to fulfill the criteria or the requirements pursuant to Section 19B. That's the first. I hope I've answered, not really, but I hope I've answered your first question. It's not really an answer. The second question is, what are the reasons, the first-time applications? Okay, so there aren't really any reasons given by JPN or KDN. But if I'm hoping that this individual has actually applied for 15A, or I'm guessing that they've applied for 15A before and it's been rejected, try again. The reason being, the government, we've recently seen a sharp increase in approvals for 15A applications. And honestly, we advise everybody of this. If you are eligible to apply for 15A, do it as soon as possible, do it. Because even if the first time you're rejected, the second time around, chances of being approved are much higher. There's no reasoning given, and we're not privy to the decision making of the government. But in recent times, we have seen an increase in approvals, which is a very good sign, at least in terms of 15A applications, which is why if this individual has applied or is applying on behalf of somebody, we would recommend applying again. There is nothing to stop you from applying again.
Thank you so much for addressing that, Kirthika. I see we also have another question from Martin Nicholas. Martin, I see you were very detailed in your questions. I do think we are running out of time. If it's okay with you, I think I'll get Kirthika and Aishah to contact you after the end of the talk, because I think you have some very interesting questions, and I think Kirthika or Aishah will be happy to address your specific queries. I see there's another question from an anonymous attendee. So the situation is, mother is a citizen of Malaysia, father is a citizen of another country. Their marriage is registered in Malaysia and the child is born outside of Malaysia. Would the child be eligible to be citizen of Malaysia? Aishah, maybe you can take it.
Thank you, Anis. I understand the question is, the mother is a citizen of Malaysia and the father is a citizen of another country, but their marriage is registered in Malaysia, but the child is born outside of Malaysia. Would the child be eligible to citizenship of Malaysia? So the short answer to that is no, the child will not be eligible to the citizenship of Malaysia. Maybe if you have any further queries, we can schedule a consultation to discuss that in details.
I can just add on to Aishah's answer. The answer is, unfortunately, as the law is right now, the answer would be no. However, we are hopeful that the cases of Aishah Sulaiha and others, which is currently on appeal, pending appeal at the federal court, we are hopeful of a positive outcome. So in the event the law does change for the better, then there is a potential that you may be entitled to citizenship. So perhaps, as Aishah said, you can schedule a consultation with us and we can discuss it further if you're interested, especially given that the cases are due to be at the end of this year.
Okay, I think there's no other questions except Martin's pending questions, which we will be in contact with you. Don't worry. Before I conclude, we have a few announcements to make. First, please join us for our upcoming talks. You can fill in our feedback form and tell us what you thought about today's session. There's an option for you to suggest topics you want us to cover, which would help us help you. So do click on the form posted in the chat box. Please do follow our accounts on social media. We're on all of them, as you can see on screen. If you would like to speak to our lawyers, we offer a complimentary consultation for up to 30 minutes over the telephone or over video conference. Please fill in the form on our website, and the link is posted in the chat box, and you may scan the QR code on screen. So all of you who had very good questions, very specific and dependent on a few things that Kirthika needed to know before she gave you a final answer, do reach out to either her or Aishah, because they would be able to assist you better, especially with to give you more time and not be pressed for time after this talk. And so thank you once again for joining us today. We truly hope you found the session helpful, and we look forward to seeing you again for our next session.